Thank you, Mr. President. I quote, 1. Germany shall immediately suspend its aid to Israel, in particular its military assistance, including military equipment, insofar as this aid may be used in the violation of the Genocide Convention, international humanitarian law, or other peremptory norms of general international law, such as the Palestinian people's right to self-determination and to not be subject to a regime of apartheid. 2. Germany must immediately make every effort to ensure that weapons already delivered to Israel are not used to commit genocide, contribute to acts of genocide, or are used in such a way as to violate international humanitarian law. 3. Germany must immediately do everything possible to comply with its obligations under humanitarian law. 4. Germany must reverse its decision to suspend the funding of UNRWA as part of the compliance of its obligations to prevent genocide and acts of genocide and the violation of the humanitarian rights of the Palestinian people, which also includes the obligation to do everything possible to ensure that humanitarian aid reaches the Palestinian people, more particularly in Gaza. 5. Germany must cooperate to bring to an end the serious breaches of peremptory norms of international law by ceasing its support, including its supply of military equipment to Israel that may be used to commit serious crimes of international law, and that it continue the support of the UNRWA on which this organization has counted and based its activities. End of quote.
Je remercie le greffier. Immédiatement après le dépôt de la requête et de la demande en indication de mesures conservatoires, le greffier en a transmis un exemplaire original au gouvernement de l'Allemagne. Il a également informé le secrétaire général de l'Organisation des Nations Unies. Au terme du paragraphe 1 de l'article 74 du règlement, une demande en indication de mesures conservatoires a priorité sur toute autre affaire. Il est précisé au paragraphe 2 de ce même article que la Cour doit statuer d'urgence sur une telle demande. Cet impératif doit néanmoins être concilié avec la nécessité de fixer la date des audiences de manière à donner aux parties la possibilité d'y être représentées. La Cour a décidé que ces audiences s'ouvriraient le 8 avril 2024. Je voudrais à présent souhaiter la bienvenue aux délégations des parties. Je prends note de la présence des agents et conseils du Nicaragua et de l'Allemagne. La Cour entendra ce matin le Nicaragua en son tour unique de plaidoirie sur sa demande en indication de mesures conservatoires. Nous entendrons l'Allemagne en son tour unique de plaidoirie demain, mardi 9 avril 2024 à 10 heures. Chacune des parties disposera de 2 heures maximum pour présenter son exposé oral. Pour l'audience de ce jour, le Nicaragua pourra, si nécessaire, poursuivre un peu au-delà de midi, compte tenu du temps consacré à mes observations liminaires. Avant de donner la parole à l'agent du Nicaragua, je souhaite appeler l'attention des parties sur l'instruction de procédure 11, selon laquelle, et je cite, « Dans leur exposé oraux sur les demandes en indication de mesures conservatoires, les parties devraient se limiter aux questions touchant aux conditions à remplir aux fins de l'indication de mesures conservatoires, telles qu'elles ressortent du statut, du règlement et de la jurisprudence de la Cour. Les parties ne devraient pas aborder le fond de l'affaire au-delà de ce qui est strictement nécessaire aux fins de la demande. » Fin de citation. I now give the floor to the agent of Nicaragua, His Excellency, Mr. Carlos Arguello Gomez. You have the floor, sir.
Mr. President, members of the court, good morning. It is my honor to come before you representing Nicaragua in a case involving its rights and obligations, as well as those of the entire international community, and most importantly, those of the Palestinian people. The case before us involves momentous events affecting the life and well-being of hundreds of thousands of people, and even the destruction of an entire people. But in spite of the gravity of the situation, the facts and the law are very simply explained. Serious breaches of international humanitarian law and other peremptory norms of international law, including genocide, are taking place in Palestine. These breaches are being committed openly, have been witnessed on the ground by thousands of people, and have been viewed on public news services and social media by probably the majority of the population of the world. When a situation of this nature occurs or is in danger of occurring, the obligation for all states are clear. Not only states must not abet the situation by aiding or assisting the perpetrator, but they must use their best efforts to ensure respect for these fundamental norms and prevent their breaches. With respect to these obligations, there are no third states. All states are under the obligation to respect them. They are erga omnes obligations. Germany has violated these obligations imposed on all states. Mr. President, Nicaragua is not a newcomer to the court. On 9 April 1984, tomorrow it will be 40 years, Nicaragua filed an application against the United States for serious violations of international law against its rights and sovereignty. The present case is different, but it has a striking similarity. 40 years ago, in this month of April, during the hearings on provisional measures requested in that case, Nicaragua was asking, among other things, that the court order, and I quote, that the United States should immediately cease and desist from providing directly or indirectly any support, including training, arms, ammunition, supplies, assistance, finances, direction, or any other form of support to any nation, group, organization, movement, or individual engaged or planning to engage in military or paramilitary activities in or against Nicaragua. End of quote. In the present case, Nicaragua is also requesting the court to order that Germany should cease providing support to Israel in its campaign of destruction of the Palestinian people. But in the present case, Nicaragua is acting not only on its own behalf on the basis of the rights and obligations conferred by the peremptory norms invoked, but also on behalf of the Palestinian people that is being subjected to one of the most destructive military actions in modern history. Beyond its legal rights and obligations in bringing this case, the government and people of Nicaragua have a special sympathy for the plight of the Palestinian people. Nicaragua has not had to suffer the levels of inhuman treatment and destruction that has been the fate of Palestine for more than three-quarters of a century. Nonetheless, it has also been subject to intervention and military attacks for most of its existence and feels empathy for the Palestinian people. On the subject of empathy and sympathy, it is of note that Germany emphasizes that its assistance to Israel is a raison d'etat because of the historical treatment of the Jewish people during the Nazi regime. That is an understandable and laudable policy if it were addressed to the Jewish people. The Israeli state, and particularly its present government, should not be confused and equated with the Jewish people. The real friends of the Jewish people should emphasize the difference. The Jewish victims in the concentration camps during the Second World War would feel sympathy and empathize with the more than 30,000 civilians, including 25,000 mothers and children massacred so far in Palestine, and the 20,000 children orphaned, and 2 mothers being killed every hour. States like Germany that sympathize with what the state of Israel was meant to represent when it was created should be doing their best to put a stop to what is happening and not continue backing Israel in practice, even though they now, at least in public, perhaps forced by the enormous public outcry, make statements for peace 6 months after the start of the massacre, perhaps also in reaction to the present case before the court. With all due respect to this moral imperative of Germany that identifies defense of Israel as a raison d'etat, there is another less noble reality that perhaps is not known by the generality of the German people. There is also a lucrative quid pro quo involved. German companies involved in the military industry are directly profiting from the situation as they have seen their share prices rise since 7 October. And they have substantially increased their joint development contracts for weapons with their Israeli counterparts. Proudly and openly, on November 23, 2023, the Israeli Ministry of Defense announced that they had officially concluded an agreement to sell the Arrow 3 air defense system to Germany for an estimated $3.6 billion, describing it as the largest ever defense export of Israel. The Israeli Defense Minister further described the moment as, and I quote, an emotional moment to be here as the son and grandson of Holocaust survivors on German soil in Berlin to sign a defensive arms contracts. It's very important personally and diplomatically. This moment of history leans on our past and dictates our shared future. He called the sale a moving event for every Jew. End of quote. As has been reported many times, Israel is a technological hub, particularly in the weapons industry, and Israeli companies proudly advertise their products as battle-tested. Needless to say that for years the international community has been aware that the testing field is Palestine and its people, particularly Palestinians living in Gaza. Mr. President, the present case is different than that filed against Israel by South Africa, and in which Nicaragua is seeking to intervene as a party. The South Africa case only involves violations of the Genocide Convention by Israel. In the present case, Nicaragua is invoking the responsibility of Germany in connection with the genocide committed by Israel, and also the responsibility of Germany for the violations of its own obligations under the Genocide Convention and of the violations by Germany of its own obligations under international humanitarian law. The cases are thus different with respect to the norms being violated and with respect to the form of the violations. Germany is failing to honor its own obligation to prevent genocide or to ensure respect of international humanitarian law. The violations of international humanitarian law by Israel create obligations for Germany, as it does for all states of the international community, obligations for which Germany is responsible and which are being claimed in the present proceedings. Mr. President, the fact that the acts of one state generate independent obligation for third states is not an unusual legal situation. The first case of the present court, the Corfu Channel case, involved the laying of mines in Albanian waters that caused damages to the United Kingdom vessels. The court found no evidence that Albania itself had laid the mines or that it had colluded in the laying of the mines by a third party. But it was established to the satisfaction of the court, including by the report of experts appointed by the court, that, and I quote, laying of the minefield could not have been accomplished without the knowledge of the Albanian government, end of quote. And having that knowledge, open quotes again, the obligations incumbent upon the Albanian authorities consisted in not notifying, for the benefit of shipping in general, the existence of the minefield, end of quote. This ruling in the Corfu Channel case was taken up by the International Law Commission in the following manner, and I quote, a state may be required by its own international obligations to prevent certain conduct by another state, or at least to prevent the harm that would flow from such conduct. Thus, the basis of responsibility in the Corfu Channel case was Albania's failure to warn the UK of the presence of mines in Albanian waters which had been laid by a third state. Albania's responsibility was original and not derived from the wrongfulness of the conduct of any other state. End of quote. This judgment was one of the bases for the general rule contained in Article 16 of the Articles of Responsibility of States for Internationally Wrongful Acts, providing that a state which aids or assists another state in the commission of an internationally wrongful act by the latter is internationally responsible for doing so if that state does so with knowledge of the circumstances of the international wrongful act. It is pertinent to point out that the International Law Commission makes a special note of the situation when the responsibility arises from a serious breach of peremptory norms of general international law. which is the situation we are dealing with in the present case. In these circumstances, the International Law Commission comments that there is no need to mention the requirement of knowledge of the circumstances in Article 41, paragraph 2 of the Articles on Responsibility. As I quote, "It is hardly conceivable that a state would not have notice of the commission of a serious breach by another state." End of quote. Mr. President, permit me to emphasize what the International Law Commission is pointing out. The violations of peremptory norms are facts that are evident and of public knowledge. These are not facts that can only be established by special authority and that can only be acted upon until they have been so established. They are facts that must be acted upon as soon as they have become known. The importance of this knowledge of the violations has been reiterated in other cases, and Professor Pillay will go briefly into some of them, since a short pleading on provisional measures is not the appropriate moment to go deeply into this question. Notwithstanding, a brief review of the reasons why Germany must have had knowledge and full awareness of what was happening and is happening in Palestine is useful. From the first days of the Israeli military actions in Gaza, it became evident that grave violations of international humanitarian law were being committed. Statements pointing this out were urgently made, among others, by the Secretary General of the United Nations on 9 October, by the President of the International Committee of the Red Cross on 11 October, and even at a political level with full participation of Germany in the statement by the High Representative of the European Union on 10 October, all of these on 2023. From that moment, even if the genocidal intent was not yet entirely evident, the grievous violations of international humanitarian law were evident. In practice, it was not even necessary to await these declarations in order to realize that, for example, dropping bombs of 1 ton in densely inhabited areas was a completely unjustifiable violation of the most basic humanitarian laws that had been recognized as such for many years, centuries in reality. If those statements just mentioned were not enough information to trigger the obligatory response by Germany, in your folders is a non-exhaustive list dating from 9 October until last Friday, 5 April, of 32 statements from hundreds of the most respected authorities, organizations, experts, legal scholars, and practitioners on questions of international humanitarian law, calling out that Israel was breaching or plausibly breaching the Genocide Convention and that it was breaching the most important norms of international humanitarian law. This ever-growing list includes the recent open letter of more than 600 legal experts, including 3 Supreme Court justices, calling the United Kingdom government to end weapons sales to Israel, as well as the resolution with a similar but universal call from the Human Rights Council of the 4th April, not surprisingly, with Germany's negative vote. With all this undeniable knowledge of the situation, Germany's reaction was to increase its military assistance to Israel. Its complete support of Israel, even at the political level, was manifest when South Africa filed its application on Israel on 29 December 2023. The prompt reaction of Germany was to announce that they would intervene in favor of Israel. But apart from all these public statements and warnings of what was happening, the court, in its order of 26 January, considered that genocide was plausibly being committed against the Palestinian people. From that moment on, paraphrasing one of your members, the alarm was sounded and the indications of genocide activities were flashing red. With the alarm sounded, in fact, it was a final alarm, resounding amid a horizon of alarms from all quarters. There should have been no further possibility of ignoring the situation. And yet Germany continued and still continues to this day to supply weapons and military assistance in general to Israel. The norms of the Genocide Convention, which are part of customary international law, impose the obligation on third states to undertake to prevent genocide. This obligation arises from the moment that that state becomes aware that genocide might be committed. And there can be no question that Germany, as it's evident from the preceding comments, was well aware and is well aware of at least the serious risk of genocide being committed, most certainly after your order of 26 January. The consequences of the violation of this obligation will be further addressed by Professor Pelé. In the present case, in addition to the obligations under the Genocide Convention, we are also invoking violations to other peremptory norms of public international law, particularly the norms of international humanitarian law of the Geneva Conventions, which are also norms of customary international law. Many of the violations of these norms are also part of the constitutive elements of the crime of genocide. For this reason, even if genocide were found to not have been committed, which Nicaragua does not accept, these violations of international humanitarian law stand alone and involve obligations for third states. A grievous example of this can be appreciated in the violations, among others, of Articles 55 and 56 of the Geneva Conventions and the duties of the occupying power of ensuring food and medical supplies for the occupied population. On this point, the Court noted in its order of 28 March, and I quote, "The unprecedented levels of food insecurity experienced by Palestinians in the Gaza Strip over recent weeks, as well as the increasing level of epidemics." End of quote. As one of your members pointed out, these circumstances also reflect a plausible risk of a violation of relevant rights under the Genocide Convention. But even if it were found, quod non, that provoking this famine and catastrophic situation does not amount to genocide, it is in and by itself a clear violation of the Geneva Conventions. These norms also impose obligations erga omnes, which Germany, like all other states of the international community, is bound to respect, and therefore the violations of these norms in the binding aspects that they have on third parties can be claimed, are being claimed by Nicaragua against Germany as part of this case before the court. In view of the catastrophic situation of famine and epidemics in Gaza, the decision of Germany to suspend the funding of UNRWA and to maintain to this day the suspension of the funding of UNRWA's operations in Gaza is particularly telling of Germany's support of Israel. The question of the suspension of the funding will be reviewed by Dr. Mueller. At this point, some brief comments. UNRWA has been working in Palestine almost as long as the existence of Israel as a state. It has been providing the essential needs of the many refugees in the area. During this military campaign of Israel in Gaza, nearly 200 humanitarian workers, the majority of whom were part of the staff of UNRWA, have been killed. Israel accused about a dozen of the more than 12,000 workers of UNRWA with involvement in the events of 7 October. Immediately, and based on the sole say-so of the Israeli government, Germany suspended its funding of UNRWA. Incredibly, this occurred the day after your order of 26 January. What is striking in respect to this reaction of Germany is that on the say-so of Israel, they suspended assistance to UNRWA, but they have ignored the statements and the accusations of the most important world authorities that genocide and other violations of international humanitarian law were being perpetrated by Israel in Palestine, and continue their full assistance, including military assistance to Israel. Moreover, possibly realizing the absurdity of such a decision, Germany finally reversed its decision, except for the most shocking aspect, the suspension of funding for UNRWA operations in Gaza, precisely where it is most needed to limit the scale of the humanitarian disaster. Mr. President, up to this point, Germany has had the opportunity of studying our application and will have the opportunity of listening to our pleading today and responding tomorrow. Nicaragua has not had the opportunity to be informed of the position of Germany on the legal issues involved. The only reactions of which we have noticed are those mentioned in our application and amount to simply indicating that Germany rejects Nicaragua's claims, as well as other publications, other declarations justifying their backing of Israel's actions. From the public statements made by Germany, we could note two alleged justifications for their continued support of Israel: that Israel is not violating the Genocide Convention and that it has a right to defend itself. With respect to the first point, we already pointed out the full knowledge of Germany has of what is happening in Palestine and the legal consequences of this knowledge, not only of the plausible violations of the Genocide Convention, but also of the norms of international humanitarian law. This is not a question that can be or need be addressed during these pleadings that are inevitably short since they are addressed basically to the issues involved in the request for provisional measures. In any case, Professor Pollet will have some further comments on this issue. With respect to the second point, the right of self-defense of Israel, which is also invoked by Germany for its continued assistance, some brief comments. The question of the right of Israel to defend itself is correct